Hi, and welcome to this University of Portsmouth webinar, Business Talk in these COVID-19 times. Today, we're looking at strengthening your legal trading position. Put it into some context. As we see businesses returning to a new normal, I think it's reasonable to ask businesses to ask themselves, is the legal trading position they had before lockdown an appropriate one as they emerge? We received a number of questions on this, and I'm delighted to be able to have joined with us a number of people today. Graham Quar, who is head of commercial law team at Biscoe Solicitors. Graham, would you like to introduce yourself?
Hi, I'm Graham Quar. So just heard I lead a team of commercial solicitors based in Biscoe in Portsmouth, all dedicated to providing legal advice and solutions to business owners.
Thank you very much, Graham. And also joining us from the university is Joanne Atkinson, who's from Portsmouth Law School and is a principal lecturer in law. Joanne, would you like to introduce yourself?
Yes, thank you. Hello, everyone. So my name's Joanne Atkinson. I'm a principal lecturer in the School of Law at the University of Portsmouth. I'm also a qualified solicitor, and I've worked in both private practice and in-house, most recently as company secretary of a global financial services corporation. And my research looks at credit regulation and access to credit.
Okay, thank you very much, Joanne. I think we're going to dive straight in to the questions, and our first question really sets the scene quite nicely, I think. Or there's been some debate prior to the webinar about how it will be answered, which is thinking about the fact that we receive daily briefings from various cabinet ministers, and we've heard about large pieces of legislation crossing the statute books in terms of the Coronavirus Act. It probably has a proper civil service name that I'm not giving it there. One of the questions that's come in, I think it's a good one to start with, is what, if any, are the key legislative changes that have taken place, I suppose, from a trading position and a business position as a result of this lockdown? And I think to start with, from a practical position, I'm going to come to Graham and ask, what's your view of the practical changes in the legal sort of stance?
Well, I think overall, behind all the sort of COVID emergency legislation, there's still business law as usual. So corporate law, commercial trading, contract terms, all those are still there. But of course, to deal with the pandemic, the government has introduced this wave of legislation, emergency legislation, to deal with should we be open, should we be closed, how we can deal with our customers and with our employees. But behind all of that, there is still standard commercial law, contract law, landlord and tenant law, which continues as before, generally.
Graham and Joanne, your view on that?
Yes, I agree. Absolutely right. And I think what is happening, however, is that all of this emergency activity is prompting us to review some of our day-to-day business dealings and the way in which we manage our businesses. So, for example, we were talking a moment ago about some draft legislation that's now being prepared by the Financial Conduct Authority about the status of cash in businesses and whether we should be looking to phase out cash over the coming 10 years or so. We're wondering whether perhaps the landscape on commercial leases might change. So I think Graham's absolutely right, and I agree. But I also think some of these emergency measures and restrictions are prompting us to look to the future in terms of how we conduct our business.
Thank you, Joanne. And I think the question number 2 follows on nicely from that, although it is a bit broad. And again, I'll come to Graham first, which is that one of the businesses has emailed in to say, are you receiving queries in any particular areas that you feel that businesses generally should be more aware of? So is there a common query or a sort of legal lockdown FAQ that is coming in a lot that you think that actually businesses should be more aware of?
Yeah, I think there are 2 main topics, and the first will not be a surprise: employment law. So our employment law solicitors are busy. From the beginning, furlough was very important to keep businesses going. There are lots of inquiries about what it means, how it's impacted, how it can be implemented. But sadly, of course, that's moving on to prospective redundancies, because most businesses are now looking to bring some employees back to the office, to the factory. There will be some review of how many employees companies need, and therefore we are receiving instructions, advice as to how one can review and implement redundancy procedures, which is disappointing news. Other area is commercial properties, particularly leases. Most businesses have a lease of their trading premises. Time is tough to pay the rent, and therefore the question from the tenants is, I can't pay my rent, what can the landlord do to me? And of course, landlord client saying, my tenants can't afford to pay my rent, what can I do about it? And they're two very key areas. And it's interesting, really, there's probably some just commercial debates going on. Does the landlord want to help his tenants and keep the tenants in business through what hopefully short-term difficult times, and give the tenants a rent-free period, but keep the tenants in the long term? Or does the landlord take a more vigorous approach, so far as he's able to, under the legislation, and tenants deciding, can they afford and what can they do? So I'm afraid it's employment issues and landlord and tenant issues are the two hot topics at the moment.
Thank you, Graham. And I suppose just coming to you, Joanne, I appreciate you're not in practice at the moment, you're teaching and doing research at the university, but looking forward, what do you think the areas that businesses should be aware of will be?
Well, I think some of the areas that we'll talk about this afternoon are around trading terms. So I think at the moment, many businesses are starting to conduct a review of all of their trading relationships, all of their terms and conditions of business throughout supply chains, and thinking about whether any of those need adjustment in light of what's currently happening and what we've learned from this crisis. So sort of contract review, terms and conditions of business, and it's the other things just popped out of my head. That was going to lead me into that. Right, yeah. So that was going to lead me into thinking about insurance cover again. I think that's something we're going to delve into a little bit deeper this afternoon.
Okay, thank you very much. So again, leads nicely to the next question, which has come in. And again, I appreciate this one is a little broad, and it may require some contextualisation by the panel. But is now the time for sole traders or partnerships to becoming a limited liability company to restrict their exposure? I'm going to come to Joe and just say, what are your thoughts on that? Should people be seriously considering, as a result of what's happening in COVID, switching to a lower risk trading model, or is that a bit premature?
I think, I think going from a sole trader or partnership model to a limited liability company, it doesn't affect your risk profile. It doesn't affect the risks arising from your trading activities. What it does is it limits your liability. In other words, it limits the amount of money that you're on the hook for should somebody sue you or should something go wrong, to the value of the company's shares. So incorporating as a company does operate to protect your personal assets, like your home, for example, provided they're not signed over to the company. On the other hand, becoming a limited liability company does come at a cost, not so much a financial cost, but at the cost of publicity. So your financial affairs would then be made public and accessible via Companies House. And it also comes at the cost of additional admin, additional reporting, and some onerous legal duties on the directors of that company. So it's a fine balance. I think perhaps some of the we've been reading about all the initiatives the government is putting in place to try to assist companies with raising money. And many of those schemes are only available to limited companies. So like, for example, the Futures Fund, which you may have read about, I believe I'm right in saying is a fund that provides finances to limited companies. But in order to be eligible for many of these schemes, you have to have been incorporated for a certain period of time before the lockdown took place. So I don't think it's as simple as saying, yes, quick, incorporate now. I think for every trader and for every business model, there's a conversation to be had, and all of those factors need to weigh into the balance.
Graham,
I agree with all of that. If you want to limit your personal liability, then becoming a limited company is the route to do it. Often, though, banks or landlords require a personal guarantee, so you may become a limited liability company, but you're still personally liable perhaps to the bank or the landlord. The other point to make is, and I'm not an accountant, there are tax views to look at. There are tax advantages and disadvantages of being partnership, sole trader or limited liability. So if you're looking at it, again, you should speak with your accountant to see what the tax consequences are of doing it. But COVID is an interesting time to review all sorts of aspects of our business, and certainly I would, if you're a sole trader or partnership, I'd have a look at what the benefits are of converting to a limited company.
Excellent, thank you. I mean, I think that leads nicely on to, we've got a series of questions that have come in that are about risk. And I suppose in due course risk and how that connects to liability. So one of the questions that has come in is a general question really about liability insurance and what people should expect it to cover. And it says, why does a business have to pay liability insurance or have liability insurance? And what does it cover? And I think there's some questions here about, would it cover unplanned losses due to COVID-19 closure and those sorts of things? So it'd be interesting, I think, come to Graham first from a practitioner perspective on your perspective on businesses and their need for liability insurance and the context of that for COVID-19.
Yeah, I mean, insurance, is insuring against a risk, and if the premium's reasonable, then it's worth insuring against. But some is necessary, some is optional. So employers' liability and public liability, those two areas are required. So that's insuring against your employees being hurt or injured whilst in their employment. You have to have that. And of course, public liability, so your customers coming into your shop or into your office or into your factory, you have to have those two areas of liability. And I guess the question there is the cafe owner, well, if a customer comes into my cafe and catches COVID-19, am I liable? I think that may well be, but just before we get too excited about that, I mean, employees may say, I was required to go to work and I caught COVID-19. Let's deal with that. But the main thing will be, how can you prove from whom you caught COVID-19? But still need to look at that. And in my view, it's all about health and safety. So even before COVID-19, if you're a restaurant, there's obligations upon you to avoid food poisoning incidents in your restaurant. So we just have a new wave in effect of health and safety, which is the government guidance on what we can and can't do in our offices, in our factories, in our shops. So I think you have to observe, be aware, and implement the COVID-19 government guidance if you're opening up your office or your factory or your shop, and in due course, your pub. And if you're complying with the guidance and someone, I suppose, is injured or hurt or gets COVID-19 and they can demonstrate it came from your workplace, if you showed you took all reasonable precautions and complied with the guidance, I think you've got a reasonable defence. The other areas of liability are product liability. If you're selling goods and services, you should have insurance, and that's your own decision. If I'm selling widgets and someone gets hurt because the widget doesn't work, then it's prudent to have your insurance. And then, of course, there's your standard insurance for your building or your desks and chairs and IT equipment. You should have that. Now, the latter one, then, it has business interruption. Often people have a business interruption cover if my business is interrupted or stopped for whatever reason, a fire to the office or a theft of equipment. And we've all seen the big debate, does the pandemic fall within business interruption? And the insurance industry has wriggled quite a lot to say it doesn't. There, the answer is to talk to your broker and examine your own insurance policy to see whether your insurance covers the interruption of your business by reason of COVID-19.
So I suppose just to follow up with that, because the term that we often hear as lay people, as non-solicitors, is force majeure, isn't it? Which is this beyond the insurance company's control or expectation. So is COVID not fitting into a box at the moment? Is it very much down to individual broker behaviour?
I've looked at Joanne on this as well, but first of all, I'm not sure whether insurance companies, they really say what they cover. If it's not covered, I think they would say, well, you've paid for this cover. And if it doesn't include pandemic, then there you are, you're just not covered. Force majeure is an interesting one in trading contracts, and perhaps we'll come back in a moment to looking at your trading contracts. And I've got a few thoughts on the force majeure clause that you often see in a contract.
Okay, and so from your perspective, Joanne, again, thinking about that need for insurances and liability insurances, is there anything you want to add?
I completely agree with, and that's a very comprehensive answer from Graham. So the only thing that we are looking at the moment on the point about business interruption insurance and the difficulty of having claims paid that are due to COVID-related losses, there's a test case coming initiated by the Financial Conduct Authority. So we're expecting to hear some more binding guidance on the extent of business interruption insurance, and hopefully in the next month or so. So watch this space.
Okay, brilliant. Thanks very much. I'll check back with you. We might, if that comes in the next few months, might put it out alongside the webinar. The next sort of question that's come through is I suppose dealing with disclaimers. So somebody's put here, as a service provider with inevitable contact with customers, albeit through my products and services. We've got one person saying, should I be changing the way I approach legal risk? And then a follow-on question, the two kind of come together nicely, that is about from a cafe and sort of saying, should I be disclaiming? So should I be, the classic, your car is parked at its own risk? Should I be saying, you enter my cafe at your own risk? Well, potentially a marketing guru might say not, but from a legal perspective, I come to Joe first. What's the sort of, is there benefit to anything like that?
Well, let me deal with the disclaimer point first then, because that's easily dealt with. So from a legal point of view, all of those disclaimers trying to disclaim liability for personal injury or death resulting from negligence are unenforceable. So from a legal perspective, those disclaimers just are not really worth the paper that they're written on, quite apart from the reputational effects of having massive disclaimers up by the counter in your cafe or your restaurant or whatever it is. So I think the situation used to be a bit more nuanced. Now that we have the Consumer Rights Act, all signs, notices, contractual terms of that nature, trying to limit liability for personal injury or death are not enforceable. On the positive side, what you can do, to go back to a point that Graham raised earlier, around your risk assessment and your compliance with all the necessary guidelines and rules around running a business, you can obtain a certificate from the from Health and Safety England, which you can print off and display in your premises. And that, I think, gives perhaps a more positive message to consumers about acting with integrity and looking after their safety.
Okay, that's interesting to know. Graham, any thoughts on the whole disclaimer? I know even the Health and Safety England certificate scheme.
Well, in contracts, in commercial contracts, we always try to limit the liability. Should there be a breach on your part of your contract, as you say, you can't exclude death or personal injury. You can exclude then other elements of a claim, but there is the Unfair Contract Terms Act, which limits how far you can go. And that's business to business. There's business to consumer, which is the consumer legislation. But it is a good time to review terms and conditions and see what they say. You can limit your liability to some extent, and that's where I guess this is my pitch of, consult a solicitor who can look at the type of business you're operating, look at your terms and conditions, and see to what extent you can limit liability should you become in breach of your contract.
I suppose that's more true if you're business to business trading, but business to consumer, it's slightly more difficult, as a cafe wouldn't typically ask you to sign up on the way in with it. Sign this contract for a cup of tea. Yeah. That leads quite nicely then. Again, we'll come to Graham with this one, as you've begun to talk about terms and conditions. And one of the questions that has come in from somebody is, and I think it's in respect to suppliers, should I be looking at terms and conditions of suppliers with great scrutiny? And if so, what should I be looking out for? So we've had a number of inquiries just generally into the university from people, which we've directed to sort of public websites and everything else around, if I've got cash flow problems and I can't pay for my goods, what can I do there? You touched earlier on the lease issue of, I've got a tenancy and I'm going through a period where I can't pay for it. And all of these, I think, come into people's mind as reviewing terms and conditions, either with them supplying or suppliers to them. What do you think people should be turning their attention to, perhaps reviewing at the moment?
Yeah, I think when everything is good and there's no real issues, no one ever reads those terms and conditions apart from solicitors. But now, there are commercial challenges for everybody, and therefore people now reach for the terms and conditions to see what they say or don't say. So first of all is to review your own terms and conditions, see if they're up to date, see if they deal with the kind of business you're in. I'll come back to a couple of examples in a moment. There's also, without being too technical, the battle of the forms. When you're trading in business to business, whose terms and conditions apply? Is it yours or is it the other parties? And there's a debate about that. So one is to make sure, if you can, that as you close the deal and the contract is formed, it's your terms and conditions that apply, not theirs. Things to look at in your terms and conditions, we've just mentioned liability, so just see to what extent you can limit the liability should there be a breach. But I'm thinking, looking again now at payment terms, delivery times. Have you been signing contracts that pins you down to fixed delivery dates, or should there now be some more flexibility because of external circumstances? Can you extend payment terms, asking you pay by installments, or can your buyers pay quicker? So looking at those provisions. And then there's the force majeure clause, which basically, if it's well drafted, said events outside of our control mean that the contract cannot be formed in quite the same way. So COVID may mean that you can't complete constructing or making the widget because your own material supplier couldn't get the materials to you. And if you've got a particular customer who's been difficult about that, force majeure may help you say, well, I can't deliver on time because of acts of God or acts outside my control. And that may give you some arguments not to be sued for not delivering on time. Look at your force majeure clause. No one ever does. Does it include the word pandemic? Because if it does, then that gives you some reliance. But I think the key things are we're looking at kind of timetables. Often clients sign up to say, I will definitely deliver this on the date of. I think in future, you want your contracts to be a bit more flexible on several terms, because we know the world is not as straightforward as it used to be. But yeah, read your, and if your terms and conditions don't apply because the other parties say mine apply, and of course the big companies insist that theirs apply, then read them to see what you're committing to.
Okay, thanks for that, Graham. And coming to you, Joanne, just as Graham was talking there, and he talked about force majeure, and it's an area that early in lockdown I recall a number of organisations sort of saying they can't claim on their insurance until government declare X as an emergency, or those sorts of things. Are there any aspects of that? Is it any of it in government control, or is it all in the terms and conditions?
So, as Graham just said, force majeure in commercial contracts is a kind of it's a way of sharing risk. Things won't work out as you expect. So, generally speaking, if you sign up in a contract to do something, you're doing it, regardless what else happens, regardless if it becomes more difficult, more expensive, you have to throw more resource at it. If you've signed up to do it in a contract, generally speaking, you have to do it. And that's the case. That's the case if Brexit happens, that's the case if SARS happens, if COVID happens. Force majeure terms in contracts, as Graham's explained, they effectively say, if any of these things mentioned in the force majeure clause happen, then all bets are off. Then let's talk about it, then let's agree a different delivery time or a different cost or whatever it might be. So it really is a case in every instance of going back to the words of the clause to see what's in there. Now, more modern contracts tend to include words like pandemic, and as Graham's explained, because the World Health Organization has now said COVID is a pandemic, that kind of triggers that a force majeure clause in those terms. But things that are drafted a bit more widely, so for example, that talk about acts of God, it's more debatable whether they would be triggered by current circumstances. I think they might not, actually. So it is a case of going contract by contract and line by line. It's one of these rare occasions when the contract does come out of the drawer. We need to actually turn the pages and try and remember what was in there. And going forward, thinking about what happens if things go wrong, and when would we expect all bets to be off and to be round the table again renegotiating. It's hard at the beginning of a relationship, isn't it? You know, when we signed these contracts, we were all high-fiving and very excited about working together, and we did, you know, it's difficult to have the conversation at that time about what happens if things go wrong, but it will be in there.
Just one small point on force majeure. Often it says acts of government. And I think the interpretation of that is if the government has required you to close your business, so your pub must close, that's the law, that would be, I think, an act of government. If the government recommends that you open your office, or recommends you should close the office, should I say, then that might not be an act of government. So that the similar conversations with regards to insurance, but for force majeure, an act of government is a legal directive, thou shalt close. So I think for pubs and restaurants, you know, they should be looking at that clause.
Yeah, I was just literally going to ask you that question, so thank you for clarifying that. And moving on, a number of questions which you touched on in your introduction, Graham, around lease, office space, tenancies, all that sort of thing. And the crux of the questions, I think, actually, is that obviously people read the headlines and they've seen the headlines about the government. I wouldn't necessarily say mandating. I suspect they've worked with banks to agree, but have made the option of 3-month mortgage holidays available for the general public to help ease that cash flow problem. And I think the sort of question here is people thinking about, they know that there isn't a facility per se across the UK for that in lease and tenancies, but how should they be approaching an issue with a lease? So a classic example, I suppose, if a business has been shut down for the last 12 weeks, their cash flow is probably very low. They've probably signed a lease that is, or a tenancy agreement that is well over 12 months. And they need to have a conversation with their landlord. Graham, how would you approach it?
Yeah, I mean, a lease is a contract. So if you've signed a lease for 3 years, you have to pay the rent for 3 years and comply with the obligations. So you're a pub and you've closed. You can't trade. There's absolutely no income coming in. How do you pay the rent? The government has imposed a rule, I think it expires at the end of this month. I think maybe extending it, that the landlord cannot, for the moment, and I say for the moment, forfeit or cancel your lease. But he can still make a claim for the rent and can still start court proceedings for the rent. But why would he, and what's he going to gain? So I've acted for both landlords and tenants, and I've been negotiating either deferred payments or even just rent-free. The landlord just simply saying, you can pay no rent, rent-free for 2 months, and we'll review it in 2 months' time. Because the landlords, if it's a good business, it's just been hit hard by COVID, why would a landlord want to drive the tenant out of business? Because as we come out of this, whenever that may be, and shops have opened this week, then the tenant can start picking up the rent. So a lot of landlords are biting the bullet, being reasonable, accepting that their rent income has been reduced for 2, 3, 4, 5 months. But if in the long term the tenant picks itself up and gets through this, then you continue that long-term relationship. Some landlords have been very difficult, and I mean, I guess some tenants are perhaps suggesting they can't pay the rent when they can. But it is a contract, and if you've signed to pay the rent every month for 2 or 3 years, you should be paying it. But my experience is most landlord and tenants are talking to each other and looking to find a compromise between them to keep the tenants in business, which the landlord wants in the long term.
Yeah, it's interesting you bring that in, because we've had a few inquiries come into the university, typically around retail, actually, where I think in retail you get a real mix of private owned buildings and buildings that are owned as part of investment corporations, particularly on the big high streets or in the large shopping malls, you know, the custom built kind of areas. And actually, I come to sort of Joanne, which is to follow up on that, is that if you have got a very difficult landlord and you've tried what Graham has said and they're not willing to let you off, it sounds fantastic that for the time being, as I've interpreted that, they can't cancel your lease, therefore they can't effectively evict you, whatever the appropriate legal term is. But what would be the potential exit strategies for there, both in terms of you can't come to an agreement, or perhaps any mechanisms that you can use to try and deal with that?
Well, I think Graham's point is really important. So all of these contractual relationships that we've talked about today, which are now under review, and we're looking at them perhaps with fresh eyes, you know, we're trying to assess the value of these relationships and how, you know, what are we prepared to sacrifice in order to keep them going, or are they really that valuable to us? And all of these points, I think, as Graham rightly points out, are up for negotiation. And I think the first step contracts don't always have to end in suing or court cases. They can evolve, and they can change as conditions change, and that has to happen by a two-way process or multi-way process of negotiation, and that has to be the first step every time, I think. If things can't be resolved by negotiation, there's always the option of going to a more formal dispute resolution process before triggering a breach of the lease or a forfeit or anything of that nature, if that's available. So, there's always the option to look at mediation or other forms of alternative dispute resolution, where an impartial third party will come and encourage everyone to put their concerns on the table and see whether a mutually agreeable settlement can be reached. And I think, that's a realistic and commercial way of looking at all of these issues. There's some recent guidance has come out of the Cabinet Office about commercial contracts and how businesses should be looking to implement or otherwise their contracts. And the guidance is very much around, let's try and be reasonable. Let's try and ensure that supply chains remain stable where possible. Let's try and keep cash flowing through that supply chain where we possibly can. So I think Graham's approach is absolutely the right one. And, a commercial, realistic negotiation is always got to be the first step, and then progressing to perhaps slightly more formal means of dispute resolution if that can't be successful.
Okay, thanks very much, Joanne. Just one question that has, before we go on to the final one, question that has come through on the messaging kind of system. I think this is when, Graham, you were talking about the various insurances and liability insurances. It's one of the, what about in regards to covering loss of earnings during lockdown and the cost of what needs to be implemented to open up? So I suppose in some respects they're talking about the fact that the shop fitting business has probably never been so buoyant in such a short period of time, with fixing perspex screens and 2-meter barriers and all that sort of stuff. Are these the kind of costs that you could expect to recoup from an appropriate liability insurance?
I can't think of one. I mean, what you're saying is that because of COVID, my business has become more expensive because I've had to put in this screening and the safety. I mean, that's the cost of business. You can't insure. If my business overheads go up, can I insure against that? I'm afraid it's the problem. And I think things like pubs and restaurants, they're weighing up the cost of having to implement these various infrastructure. What does that cost? And if they can only get 20% of people in them before, is it worth it? So there's going to be some commercial decisions of how much do I have to spend to make my shop or my restaurant fit for current purpose, and what is the financial return? But I'm afraid I can't think of any insurance that covers increased costs because of a pandemic.
And the other part of that question was loss of earnings. I'm guessing that's just about having a personal insurance policy for that purpose, but
I guess individuals, you get these loss of earnings, but when do they kick in? That can be expensive. And I suppose the business version of loss of earnings is the business interruption insurance, which, come back to where we were a few minutes ago, is I've insured in case my business is interrupted by something. And the classic would have been if my office burns down one night or my shop, then the insurance company would pay up for your losses whilst the shop is reinstated. But this is back to that case coming up, an important case to see whether these business interruption policies would cover the extra costs or the loss of earnings arising from the pandemic.
Okay. Is there anything you'd like to add to that, Joanne?
No, I completely agree. And I think, without wishing to be unhelpful, not all of these risks are legal risks. And, Graham's absolutely right. There is no business without risk. And so, as part of the kind of the stock taking that we're doing at the moment, part of that has to be an assessment of what level of risk, what's your risk appetite like, and what level of risk is acceptable. And again, that's an individual decision.
Okay, that's the end of the questions that were submitted. What I wanted to do before we summarise is just come to you each and talk about, because we like to do this on all of our webinars, positive examples in these lockdown times. So Graham, I'm going to come to you first and say, are there in sort of practice law that you're doing at the moment any positive examples of people taking legal advantage or making legal a positive of what's going on?
Yeah, I think first of all, just the heading of this seminar is strengthening your legal position. And really, I think the theme has been looking at those contracts, be it the lease, is there a break clause in there to allow you to leave early, looking at those terms and conditions, which have suddenly become important. They've been collecting dust in the drawer. So when life becomes difficult and commercial contracts are under pressure, look at your terms and conditions, understand them and see if they can be improved, and therefore strengthening your legal position. If you're negotiating a new lease for your office, factory or shop, think about early termination clauses that give you an exit clause. And these are available, but take advice from experts when you're going into those contracts. I think any challenge or change provides opportunities, and there are some businesses that are looking to take advantage of that. Online shopping, of course, has become even more popular. Some of these bricks and mortar businesses, I think, will be looking more urgently at their online presence and how they can improve that and how they can deliver a service. Recruitment, of course, and it's sad to say this, but this might be a very good time to recruit, because sadly there'll be people coming onto the market, and if you're looking for really good talent to build your business up, then you might well find that the pool of talent is greater than it was 6 months ago. My just final thought is just thinking from a view of opening up your business and working with clients and doing that. My theme would be, don't see it as a reopening, see it as a new startup. This is a fresh beginning. How can you present your products in a different way? Retraining your staff to deliver the customer service differently. So if you are, as the pubs and restaurants open, it will be different, but you can take advantage of that. Come at it with, this is a new startup, a new way of doing it, and go at it very positively, rather than just see the kind of obligations of screens and less chairs and less tables. So yeah, when you go back, as we're opening up, it's a startup, not a reopen, and make it exciting.
I like that. It's a very nice way of thinking about it. We had a webinar last week about workplace resilience, and Jane Carrington was on it, and she said, I don't like the term bounce back, I like the term bounce forward, and it's a similar kind of sentiment. And Joanne, from your perspective, looking at the research and the activity in legal development and everything else, are there any positive examples of things coming out of COVID?
It's very early. It's very early to answer that question. Things grind on quite slowly, don't they, in terms of law generally? But I think, I couldn't agree more with Graham's assessment. I think what's happened is a game changer. And without wishing to diminish the negative effects of that, which we're all well aware of, a game changer can offer positive opportunities for change as well. So we've talked a little bit about perhaps payment mechanisms, and do we all need to still march around with bundles of paper in our pockets to make payments and so on? And so I think there are opportunities there, and I think we will see changes to the legal landscape going forward. But I think for now it's a matter of being agile and trying to capitalise on the opportunities that we've talked about. It's about having that kind of wholesale review of your business model, and in particular of all of your terms and conditions, and just seeing whether they can be made a bit more effective, perhaps a bit more resilient. And certainly there are opportunities there as well as downsides, for sure.
Okay, thank you very much for that. Just quickly looking through my notes and summarising today's webinar, it was good to hear from you, Graham, that on the practitioner law level, it's employment law and trading terms that are the big areas of inquiry, and actually then subsequently trading terms or looking at your terms has become quite a strong thread running through today's webinar. I've certainly learned that employer and public liability are mandatory and all others are optional, but perhaps that's why I'm not a solicitor. Good to also know that disclaimers actually potentially are enforceable when it comes to personal injury, and that perhaps they're not the best reputational approach of your business. And this idea of getting in touch with Health and Safety England, perhaps having a certificate and putting a positive slant on your approach to risk, and therefore subsequently the legal liability that comes from that. I'm definitely going to now read every force majeure clause that I'm ever asked to sign, courtesy of Graham, and I'll be looking for all sorts of dramatic words like pandemic and epidemic and and all those sorts of things. But also, I think the nice thing here is the personal side of law, which has come out towards the end of the webinar there, around talking to your landlord, remembering that it's about dispute resolution, not necessarily about suing and litigation. And actually, I think I'm going to finish on Graham's point, which I think, although not potentially a legal point, which is if you're about to get back into business, why not treat this as a startup opportunity and an opportunity to try some of the things you haven't done before, or perhaps let go of some of the things you just always did, and consider it like you're starting a new business over again. Absolutely wonderful sentiment, I think, to end a legal-based webinar. I'd like to say a massive thank you to Graham and to Joanne for giving us their time today, and taking it out of their busy schedules to come and answer some of these questions. We will be back again next week, and you will see advert from that on the university website. So have a lovely afternoon, everyone who's watching. Thank you very much, Joanne, and thank you very much, Graham, and we will see you all